My questions are there any misdemeanors that should be added or made not eligible? And, there are some misdemeanors that are not eligible that I wonder about if there shouldn't be a certain amount of time. Where, for example, failure to follow sex offender registry requirements. It's a lifetime you could never get off of it. And that could be a minor infraction of, questionable about where you're living. So I wonder about that one. That's just an example. And then are there any felonies that should be added or deleted that they've listed in terms of the felonies? And then what is the sealing procedure and how does that all work? And I wanted to, the number of years. So qualified misdemeanors are 3 years. Qualifying felonies are 7 years. Do we agree with that? DUIs 10 years. Denial of petition 2 years unless shorter duration is authorized by the court. And I had a question mark next to that. I don't understand. If the court denied it, shouldn't we say 2 years for everybody? And then the access to reports is the other issue that we need to deal with. Who has access and how does that all work? So those were just as I reviewed the bill. And then Section 9 is an automatic stealing study committee. And I'd like us to consider if we really need to do this, that justice oversight would be an ideal committee to look at that rather than setting up another legislative study committee.
I agree.
Yeah.
Those are just some of the things when I reviewed the bill, and maybe folks who are testifying today may want to comment on those or go in whatever direction you'd like. And our first witness is located in another state, which I won't mention for his own protection. Oh, seriously, David, welcome to Senate Judiciary once again. We really appreciate the Justice Center's willingness and your willingness to help us with a variety of criminal justice reform issues. So thanks for being here.
Senator, thank you very much, and thanks to the members of the committee. My name is David Demora, for the record, and I'm a senior advisor at the Council of State Governments Justice Center. With me this morning is one of my colleagues, Josh Gaines, who is an attorney here at the Justice Center and who dives ever more deeply into some of these issues than I do. So I'm going to give you some big picture takeaways, pieces of information, and then Josh is going to add some additional points related to some of your questions and related to some of the things happening in other states. But first of all, just to sort of give you an overview of what's going on around the country, virtually all the states have something in place looking at the issue of sealing. 14 states have very broad eligibility for most felonies and misdemeanors. Another 22 states have broad eligibility for almost all misdemeanors, but a more limited but still significant number of felonies. So you have 22, 32, 36 states currently really looking at this issue in terms of sealing. Some of the states, or I should say all of the states, do have offense-based exceptions in place. There are some carve-outs making specific offenses or classes of offenses ineligible, but the scope actually varies dramatically across the states. The most common ones, perhaps not surprisingly, are for violent offenses, for sexual offenses. Less commonly, you see some carve-outs for DUIs and for domestic violence offenses. When I say less common, overwhelmingly, the most common have to do with carve-outs related to sexual offenses or severe violence. When I say less common, I don't mean to suggest that that doesn't occur in a significant number of states. It does, but it's not as widespread as when we're talking about the carve-outs that we see related to sexual offense behavior. And to be clear, Senator, When I talk about that, I'm talking about the issue of the offense, not the issue of the misdemeanors related to the registry issues. That's a separate issue, if you will. Most states that have this option require the folks that are seeking relief to actively request it via a petition to the court. There are 10 states that provide automatic relief. They don't require any action on the part of the person that's receiving relief. However, in those cases, the automatic releases typically have much longer waiting periods, and therefore a relatively small number of offenses. In many of those states, those 10 states, discretionary petition-based release is also available as an alternative, which allows folks to get relief earlier for a broader array of offenses. Relief is discretionary in most states. Whether the eligible person gets it is up to the court. States vary to the degree of the number of rules they give the court, how much discretion they give the court. Some states have a lot of specifics about how the court has to act. Other states have far less standards and leave it up to the judicial system. With very rare outliers, the absolute upper limit on waiting periods is 10 years. However, when that 10 years starts varies. And so in some cases that might start upon completion of sentence. In some cases, it might start upon period of time within the community. In some cases, it might be related to completion of program requirements that they may have been ordered to be involved in. The waiting periods, not surprisingly, tend to vary with the severity of the offense, as well as whether or not relief is granted automatically. Those, as I said, have longer waiting periods. For misdemeanors, however, in many states, expungement of those is available immediately upon completion of sentence or within a very small handful of years after, like 1 to 3 years. So what you see are the vast majority of states really looking at this issue of sealing records, or in some cases expunging records. You're seeing a broad variation among sort of the comfort level. You see differences in terms of timeframes, but you do see a significant number of states really looking to solve that problem, if you will, deal with the issue of sealing very quickly for misdemeanors upon completion of their sentence. And the vast majority of states, as I said, really look at this as a discretionary, not an automatic process that involves the courts. Josh is going to pick up here and talk a little bit about some of the specifics around the authorities and also who gets information, who can access the available information once something is sealed. So Josh, I'll turn it to you, and then we're happy to take any questions.
Josh, just for you and for other folks who may not have been with the committee before, I'm Dick Sears from Bennington County, the chair of the committee and a member of the Justice Center Advisory Board. And Senator Baruth, if you want to introduce yourself and then go around the room.
Sure. I'm Phil Baruth, and I represent Chittenden County, and I'm the vice chair of the committee.
I'm Jeanette White. I represent Wyndham District, and I'm just a member.
I'm Joe Benning. I'm just another member too. I'm from the Caledonia County District, which is in the northeast quadrant of Vermont.
I'm Alice Mitka. I'm from Windsor District. South, a little ways. All set.
All right. Thanks. Yeah, I'm Josh Gaines. Thank you, David, and thank you, Chairman. A project manager here on the economic mobility team at the Justice Center. Had the pleasure of speaking with you all last session, but it's been a while, and I know you all have been very busy, as have I. So nice to see you all again. I just kind of wanted to step back and kind of tie, I know David got into some of the sort of specific numbers and ranges that we're seeing in the states, but just kind of give an idea of what sort of the key attributes are amongst the states when comparing their expungement and sealing laws, and also talk about how those interact, because I think it's really important to look at all of the, kind of permutations in the models, because each little change really affects the other attributes. So I'll give you an example. David mentioned automatic expungement, how when expungement or sealing, however it's styled, is automatically granted, the waiting periods tend to be longer, which makes sense because at that point you're playing with averages as opposed to considering folks as an individual, where it might be more appropriate to give that individualized consideration early on. But I'll just step through these attributes and kind of touch on what that interplay might be as we go, and hopefully that that can be helpful to you all as you consider the bill. The first is, of course, offense eligibility. What offenses, classes of offenses can be cleared, right? Generally, misdemeanors are widely available, and some felonies. And in many states, almost all felonies are, but certainly, misdemeanors, lower level offenses are more likely to be eligible. Waiting periods, as David mentioned, how long you have to wait, and then how that waiting period is measured. And I want to kind of stress that the waiting periods aren't always just measured in time since conviction or time since release. In a significant number of states, they're measured in time since your last conviction for whatever it was. So we're really talking in a lot of states of years crime-free. So a 10-year waiting period might be 10 years since you've had any involvement, which, when you think about it, makes sense, especially when we're looking at the data about recidivism, knowing what we know about a person's chance of reoffending dramatically decreasing as they go longer and longer without receiving another offense. The next distinction is whether expungement is petition-based, whether you have to ask for it, or whether it's granted automatically. Closely connected with that is whether it is mandatory versus discretionary, right? Which is a different issue. There are a number of states where you have to go to court and ask for relief. And if you meet objective qualification requirements, such as you've satisfied the waiting period, your offense is eligible, the court has to grant it, right? But they're not going to do it automatically. You have to go and ask. And the vast majority of cases, of course, relief is discretionary, right? You ask the judge, even if you meet those initial eligibility requirements, there's subjective determinations that a judge can make, and that will determine whether you, in your specific case with your specific criminal history, will receive relief. The other is broad criminal history-based eligibility requirements. So a lot of states take a holistic look at your criminal history. For example, there are a number of states where if you have had any felony conviction at all in any period of time, you are not eligible. If you have had, more than a certain number of convictions for felonies or misdemeanors, you are not eligible. And that could, obviously work in different combinations and does in different states. So, they really want to look across your life at, kind of the broader criminal history, which kind of makes sense when you think about the risk assessment involved here. And then the last important part is really the effective relief. So we're talking about who can access records, right? Law enforcement, prosecutors, courts, employers, private entities, landlords, of course, but also what rights and obligations attach to folks as a result of you receiving relief, right? So in many states, receiving expungement is not, or sealing is not just, taking the record out of the public view. It grants you certain rights, right? Like the right to receive a license, for example, that you might not have otherwise been granted, the right to obtain or be employed in a position that statute might otherwise bar you from being employed in, the right to deny the existence of your criminal history if you're asked by an employer, by a state agency, sometimes even by a court. The legal effect of sealing can vary widely among states. And I, see that the bill does kind of touch upon some of that in terms of, what employers are allowed to ask about with respect to an expunged record. But having kind of laid all of those out, I think you can sort of see where every state lands in terms of, what's eligible, how long it takes before it's eligible, these sorts of considerations. all kind of depend on what everything else looks like, right? Because the level of sort of risk, the level of individualized consideration, the degree to which you were playing with the numbers and what those numbers look like is going to vary a lot depending on the amount of discretion that the courts have to grant relief, for example, what kind of relief it is you are actually granting, for example, and then, you know, what broad criminal histories the people who you are granting relief to may have. So that's just kind of to lay out sort of, you know, briefly in summary, kind of a landscape of what the other states look like and why they look like that. Because I don't think it's arbitrary when we talk about there being a big range of how states handle it. I don't think they're looking at this, you know, so differently. It's just that the models, you know, every little bit kind of reflects and changes the other pieces. So happy to answer any questions you all might have.
I think the first question I have is terms of access to the records, which you kind of touched on, but are there states where law enforcement has access to the records when they make a traffic stop, for example? Are there states that have access to records for certain professions or banking, that sort of thing?
Yeah, so law enforcement is almost across the board granted access to records, at least in some capacity, usually in an unlimited capacity. So in effect, the records are sealed from view to anybody except law enforcement, and you know, law enforcement can maintain those in their own database, request them from the courts, and use them, you know, for whatever legitimate purpose they can. Courts as well often get to retain access, and this is largely for repeat offender sentencing purposes, for calculating predicate offenses and those sorts of things, which makes sense. And there are usually kind of limitations on the fact that those records can be used only for, you know, that purpose. So they can't be introduced, you know, as evidence and at a trial or anything like that, but can only be considered at sentencing. Licensing bodies, specific employers, those carve outs are very rare. Typically, if you receive an expungement or a sealing order, licensing bodies, employers who would otherwise have access to the record will no longer have access to it. There are exceptions in that, and it's really kind of, you know, a hodgepodge of state by state exceptions. They're minimal, they're outliers, but they do, where they pop up, tend to address federal law issues. So for example, and really federal law issues and I would say in a way that is perhaps a bit overcautious, where they want to make sure that they're not running afoul of, you know, state participation in federal programs, for example, state receipt of federal funding, right, that is tied to consideration of criminal history. So there are a couple of states where mortgage licenses are like the folks granting mortgage licenses are able to view expunged or sealed records for concerns about, you know, falling out of compliance with the Mortgage Lender Act and those sorts of things. But like I say, those are all very, very minimal and rare across the states.
And I think it's important. And I think
I'm trying to specifically understand the access for law enforcement. Does law enforcement need a court order to access those records, or in other states, or do they just have them available?
So they generally have them available. If they would need court access, it would be because the court itself maintains a record that law enforcement itself doesn't already have. Typically, law enforcement will have, you know, that information before it is expunged, right, in their own repository, often in, you know, like the state's Bureau of Investigation repository, but whatever state clearinghouse for law enforcement exists, they will have that information. So when expungement or sealing order is issued, you know, if they are one of the rare states where that access would be denied to law enforcement. They would have to pull that out of their system. But if law enforcement gets to, keep access, it would just stay there, right? And I should also note that when there are exceptions to access to these records, for example, allowing law enforcement, allowing the courts, any other carve-outs, they're often accompanied by, explicit prohibitions on disclosure to the general public by those entities, right? So they can only be used for the purposes contemplated, within the exception itself, or the reason that the exception was deemed necessary.
The biggest issues in Vermont on the bill that's in front of us, the Department of Safety wants access to those records. Also, the Department of Corrections wants access to those records for risk assessment. And I know David's an expert in risk assessment, and I'm curious if a 20-year-old felony is of any use to somebody in determining whether or not there's a risk.
So the short answer is no. I've testified to this before in different committees. First of all, that it is not, departments of correction are not typically considered law enforcement. And so when we talk about law enforcement having access, we don't mean departments of correction. Second issue is just from a science perspective, it is not accurate to say that that 20-year-old felony or whatever the behavior is going to help make the plan for what is happening today. I have actually spoken now with multiple test developers because this has been an ongoing issue in Vermont. And the consistent response that I've had from the test developers is that it would be a misuse of the risk assessment information if people are using information from over 20 years ago or over 10 years ago, for that matter, in terms of determining what needs to happen. Risk and needs assessment is used to determine what you need to do to intervene. You're intervening on the issues that currently exist. If the person currently has an issue, you develop your programming, your supervisions level of supervision, your interventions around what those tools tell you is going on for this individual now. When you look at the issue of when you look at a risk assessment, there are multiple components to it. Leaving one item out or leaving items out from 20 years ago, if that person is doing well, he's going to look good on the risk assessment. Leaving the item out from 20 years ago, if the person isn't doing well, the problems are going to be caught in all the other areas of the risk assessment. Or to put it another way, somebody doesn't do well for a decade or 2 decades and then have a whole bunch of bad things from 2 decades ago that are relevant to look at and work on today. You want to look at what's going on today. What are the current family issues? What are the current employment issues? What are the current criminogenic thinking issues? What are the current psychiatric mental health substance use issues? That's what you're going to work on. And so a lot of the new tests that are being developed, and again, in talking with the developers, they're putting a 5-year limit on that. They're saying go back 5 years. This idea of going back forever creates a lot of problems, including, to be clear, increasing the disparity in the legal response to individuals and the program disparity for people of color because of what we know about certain groups more likely to be arrested or more likely to be arrested at a younger age for things that white folks would not be. So it really compounds the problem. I deeply appreciate the desire and the need to make sure the programming and response that we provide is accurate. But I have to say, and I've said this multiple times, so including to the department, and the department's done a lot of really great things. But I have to say that this particular area is really inappropriate. And that is not what you want to use risk and needs assessment for. You do not want to go back 20 years to make those decisions. And it would be, Josh, I'm not aware of a Department of Correction that has open access to this information, but you may be.
There are a few, but they are outliers.
No, this bill proposes that the Department of Corrections has access, I believe.
Mr. Chair,
Yes.
could I ask
Sure.
Joshua, I'm wondering if you can tell me, are there any states where the courts or judges have access, but law enforcement does not?
There may be. I don't have that data in front of me. I could certainly dig around for that. I suspect the answer is yes, because there will be situations where law enforcement, right, where the sole reason for the exception would be for calculating predicate offenses for recidivist sentencing schemes. And if law enforcement doesn't have access, there's, that's a separate policy determination, right? So courts having access for certain purposes and law enforcement, there's no necessary overlap. But I'll dig into that.
Okay, I'd appreciate that. And then my other question is, in terms of unauthorized disclosure, I'm wondering, it has seemed to me in thinking about it that there could also be problems with unauthorized access. So for instance, you have a state where law enforcement is not given access, but law enforcement somehow gains access, uses that in terms of how they process a suspect, but they don't disclose it. So I'm wondering, are there states where they penalize unauthorized access as well as disclosure?
There are states that impose liability for unauthorized disclosure of those records. There could also, and very directly, right, through either civil or criminal enforcement. There are states that I think try to deal with issues like that in a broader sense by saying, for example, a record that is expunged or sealed shall be considered never to have happened and shall not be used for any official purpose, at which point that use would presumably be a violation of law, but without any real clear enforcement to back that up. So I think issues like that, hypotheticals like that, have been contemplated in a lot of these laws, but how they're dealt with and what sort of specificity they are dealt with varies.
Okay, thank you.
Other questions for either David or Joshua?
I guess I have just one, Senator Sears.
Senator Nitka.
Just wondering, generally speaking, in what year did the sealing, I mean, I know it's always been around, but before it became more, when did it become fairly widespread that states were doing sealing or expungement?
That is a great question, one that I don't have a great answer to, and I really should. It has been a while. I can say that much. At least it's been widespread for at least the past decade, certainly longer, in a number of states. What I can say is that in the past decade, especially the last 6 or 7 years, really. Eligibility has expanded in states that have already made it available. They've made it available to more people after a shorter period of time. States that have had no authority to expunge or seal records, of which there were many just 6 or 7 years ago, have really caught up with the rest of the country. So there's a real trend among the states toward making this easier to obtain, and making it available where it wasn't already. And I think a lot of that is borne out just by what we're learning, and sort of what we have learned in the past about the importance of things like employment on recidivism, that data about recidivism over time, and what that looks like, and how that does or doesn't impact public safety. So it's really, there's been a lot of momentum behind it in recent years, but it's not new. What is fairly new, I will say, is automatic expungement, right? So that's just been in the last handful of years. That really started in Pennsylvania. I want to say about 4 years ago, and since then, a good number of other states, I think there are 10 now, have implemented similar laws. Those are often styled as clean slate. That term you might be familiar with, expungement. And that's an automated process where after a certain amount of time, a person with certain criminal histories, a computer actually goes through and wipes their record, and relief is granted that way. So that's fairly new, and partly just because the technological infrastructure is just now becoming available, to make that a reality.
Thank you.
Thank you.
There comments from either David? David, go ahead.
If I may just add one other thing regarding that, since Josh mentioned the issue of employment, one of the reasons that sealing has become and expungement have become much more common. Again, it's been going on for at least a decade. Even at the federal level, they've been looking at this for the last few years, and the federal level tends to lag behind the states, frankly, in terms of how these things happen. But one of the reasons for it is that a number of years back, many states worked on ban the box as a way to help folks who were returning to gain employment. And we now have some studies that sort of show there's some big limitations about that by itself, it's not as successful as we hoped, that there were ways to get around it, if you will. And so one of the reasons that one of the many reasons that states have been looking at this issue of whether it's sealing or expungement, is really to improve people's ability to gain employment, particularly given that in many cases, the kinds of licenses that were being denied were unrelated to the problem the person had, or were related to a problem the person had very long time ago and has since then been resolved. Again, there are some exceptions to that, particularly when you get into the issues of sexual violence. But overwhelmingly, what we're seeing is that we need, how to put this simply, we needed to be more effective at helping people gain employment. We know that employment is one of those things, along with family supports, et cetera, that keep people on the straight and narrow, if you will. And so we have for 2 decades now been trying to work on that and improve that. And what we've been learning as we sort of take each step is what works and what doesn't go far enough. And so one of the things I think, particularly in a state that has significant holes in employment, right? You have a workforce problem in Vermont, as many states do. The more that can be done for people to be able to get into appropriate employment, the better off the whole state is. So I just wanted to add that piece to Josh's comments about employment.
I appreciate that. Are there federal programs like housing, for example, that even after expungement or sealing, the person's not eligible for, or is that not?
It depends, and I federal law is and really interstate law with respect to expungement gets really tricky because the jurisdiction, right, of the record is the state, that ends up expunging it. But what is the effect of that expungement, right? So if it's a true expungement, the conviction is gone, and as a matter of law in the state, and shouldn't be treated as such anywhere. If a record is sealed, for example, without granting any other rights, the question remains, as a legal matter, did that happen? Does it exist? Is it relevant for other purposes? I can say that generally there is federal deference to the states with respect to records that are expunged. I know the FBI, their criminal record database, they are supposed to be, even though they have no statutory requirement to, but they do pull records that are expunged or sealed once that information is transmitted from the states. There are a number of states that do that from their databases. So for practical purposes, a record check that goes through that database would not show that information for a lot of people.
There's three reasons that people often that I speak to who want their records expunged. One is employment, which we covered. The second is housing, which they're denied Section 8 housing and other federal vouchers. And the third is gun ownership. And maybe our next witness, Jeffrey Wallen, who's with the Department of Public Safety, VCI Crime Information Center, can answer that. But those are a lot of the times people are looking for that expungement or sealing of the record to obtain those rights.
And I would just say that the effect of expungement is and sort of the scope of what you get, when you receive an expungement is really critical in making sure that sort of whatever intended impact is going to happen, right? So if you just seal a record and that's it, and essentially say, the effect of this is to make it so someone can't go to the courthouse and pull your record, and so that it can be publicly shared through official sources, then that doesn't necessarily get you very far, because there are other ways that someone could learn about your criminal history. For example, they could ask you about it, right? And that could be held against you. So if there needs to be some sort of legal effect, then I think that needs to be clear. And a number of states have done that by saying, once an order is granted to expunge or seal a record, the record shall be treated as if it never existed. And that is, as a matter of law across the board in the state and beyond.
Okay. Other questions for either of our witnesses? Hey, thanks so much for joining us this morning, David and Joshua. I appreciate it very much.
You're very welcome, Senator. We hope that it was helpful and wish you the best as you try to craft this.
It was. Thank you, as always.
Thank
Jeffrey
you.
is our next witness, who is, as I mentioned, is the director of the VCIC, or Vermont Crime Information Center. Jeff, welcome back.
Good morning, Senator. Thank you for the opportunity today. And for the record, my name is Jeffrey Wallen, and I'm the director of the Vermont Crime Information Center with the Department of Public Safety. And primarily what I want to do is hopefully answer any questions that the committee may have regarding the items we've talked about. I would make, just from the prior testimony provided, a few notes that may be helpful in setting some ground rules. Is not quite the right phrase I'm looking for, but to keep everyone on the same page, or myself at least, on the same page here in Vermont. Currently, there is a distinction between, as was mentioned by the prior testimony, between expungement and sealing. And expungement in Vermont is treated as if it never happened. So we remove that from both the state and the related federal criminal history record. It's gone, it's deleted in the most simple understanding of that word, as if it never happened. So that is removed from that event. A sealing is restricted to where it's only available to criminal justice agencies for criminal justice purposes. And to the point earlier, a criminal justice agency definition is slightly broader than that of strictly a law enforcement entity, in that it will encompass things such as the Department of Corrections, criminal courts, and a few other entities as related as well. And that's all defined in Title 20 of what a criminal justice agency is, and who may access that information. So there is a slight difference between those two things. For example, the Vermont Crime Information Center, we are not a law enforcement agency. I cannot arrest someone despite how badly I may see someone parked in a parking lot. I'm unable to do anything about that. But we are a criminal justice agency as the repository responsible for said records and maintenance of the records. As well. So I wanted to share just those two things as a matter of course. In other states, those terms can mean radically different things. In talking with colleagues across the country from time to time, other states do use those terms to mean different things, some very similar to Vermont and some very differently. So when looking at how other states do it, as the prior testimony was provided, I would encourage anyone looking into it to make sure we're comparing apples to apples here and not assuming the terms necessarily mean the same thing, because it will trip all of us up. Beyond that, I will mention, Senator Sears, to your statement and question earlier about the effects of a sealing or expungement on firearm eligibility. That is something that we do interact with here in VCIC, but I should note we do not make those determinations. Here in Vermont, those determinations are made by the Federal Bureau of Investigation, what is called NICS, or National Instant Background Check System staff. They're the ones that do that analysis. And for an expungement, which is to say it's completely removed from the criminal history record, it's deleted, it's no longer there, there's no record of it in that system, which also removes it from federal access. If that was the only item that disqualified someone from purchasing or receiving a firearm, the effect of that would be to have their eligibility restored, because there is no longer a disqualifying event. And that is for an expungement. For a sealing, I would have to defer to the individuals at the federal level, because the FBI and the NICS section is a criminal justice entity, so they do have access to that sealed information. But it is flagged as sealed and may only be used for criminal justice purposes. So I would have to defer to them on the effects of that. I would also note that VCIC is not necessarily aware of other things that may disqualify someone from being ineligible to purchase a firearm. We deal strictly with criminal history record information here. So for example, if an individual were to have been dishonorably discharged from the military, that is a disqualifying event, but we do not have access to Department of Defense records to know that even though that individual perhaps had an expungement, that they would still be disqualified from purchasing a firearm based on an external or non-criminal history related activity. So that was a lot to say, and I apologize for the word salad right off the front, but I wanted to share that information. And hopefully now I can just simply answer any questions that the committee may have.
Mr. Chair.
Senator Bruce.
Thank you, Mr. Wallen. I'm wondering, I just want to understand a little better. So when someone has a criminal event here, they're convicted, we submit the data to the NICS system, and their name is in the database as somebody who can't receive a firearm. If we expunge their record, do we then send a communication to the database indicating that they should remove it from the database?
Thank you, Senator. I appreciate that. And I'll unfortunately, I'm going to answer your question with a slightly longer answer than I would like, but I want to make sure we have it accurate. And I will say, it's also slightly odd to see myself on the monitor in the committee room while seeing myself here, because I can see myself as well. So if occasionally I'm looking off, it's just for that purpose. To your question, Senator, there is not a single database of individuals that are ineligible for firearm purchase. It works more of an individual reviewing multiple data sources, which would include state and federal criminal history records, but also, as we mentioned, Department of Defense and other databases as well, to determine if that individual is ineligible. So there's not simply a master list that exists somewhere. We do, however, append our criminal history records, for example, that have a felony conviction. We flag those as having a felony conviction, so it makes it very easy for our federal colleagues to note, okay, this person has a felony conviction, they are ineligible to receive a firearm. When that is expunged or removed from the record, and that if that was the only felony they had on their record, for example, we would remove that flag at that time, and we would also make sure the federal record, if one exists, matched the state record as well. So that's a long answer to your fairly succinct question, but I hope it helps.
When just the last sentence was a little confusing. When you say we make sure that the state record matches the federal record, do you have access to the federal record?
Certainly. So, and I appreciate the clarifying question. Thank you. The majority of criminal history records in Vermont, the way the system essentially works is Vermont, and so here at VCIC, we maintain the criminal history record, and our federal partners, the FBI, they simply refer to our records. So if someone were to query out of my home state of Tennessee, to someone, it's actually a technical pass through and we respond right out of our systems here, in the near real time. So there aren't two separate records. There's not a federal criminal history record and a Vermont criminal history record. There's just the Vermont criminal history record. There are still some where there are two records maintained at the federal and the state level, and we mirror those. And we do take control of those fairly regularly. So in an instance where there is a record at the state and federal level, we make sure those match. If there's an update to the state one, we update the federal record as well.
Okay, thanks so much.
Other question for Director Wallen? Hey, this has been extremely helpful. As a criminal justice agency, does the Department of Corrections have access to your record? Database?
They do if it's for an authorized purpose. So if they are conducting intake, et cetera, or for example, PREA analysis, the Prison Rape Elimination Act, for things like that. If those are authorized purposes to query a criminal history record, then yes, they do. They have a terminal and are able to run that to comply with both federal and safety requirements. Yes, they do.
And our juvenile records, are they held by, well, I'll ask the next witness, but I'm curious if you have juvenile records in your database.
Oh, thank you, Senator. That's a great question. VCIC does not receive family or juvenile court information. The only instances where we would, if that case was transferred to criminal or adult, as we may call it, court, and at that point it becomes information that comes over, but we do not receive family or juvenile court information. We simply don't have access to that.
Thank you. All right. Any other questions for Jeffrey? Yeah, thanks for taking time with us this morning.
So thank you, Senator. I appreciate it. And I thank you, everyone else, for their time, and have a great day. Thank you.
Jennifer Micah from DCF, maybe you can answer that first question, or, go ahead with whatever you were going to say, Jennifer. We're happy to have you with us this morning.
Good morning, Senator Sears, members of the committee. My name is Jennifer Micah. I'm General Counsel for the Department of Children and Families. And I apologize. I was sending an email when that last question came up. Do you want to remind me what that is before I go into my testimony?
Who has access to juvenile records after they're sealed? Once the sealing has taken place, does anyone have access to that record? And that was my question. Does VCIC or some other agency have access to sealed juvenile records?
So I think that's a good question for Marshall, who just appeared.
Okay.
Marshall, you wanted to take that? And do you want to let Marshall go first since he was first? Are you ready to testify, Marshall? I don't know if you had me on because Marshall wasn't quite here yet, or.
No, I had you on and then Marshall, but I don't care. If you want a tag team, that's fine.
I won't be very long, Marshall. If you have time, I can go through mine.
That would be fine. You go first.
Okay, thanks. So I'm here to discuss the Commissioner's Registry Review Unit and the effect of sealing and expungement on our work with that unit. The Commissioner's Registry Review Unit is the unit that reviews substantiations by DCF. And that unit often will rely on the work of law enforcement in the work that we do for placing somebody on the Child Protection Registry. The registry is a creature of statute, and it's intended to prevent individuals who have presented with a risk of harm to children from working in areas where there will be vulnerable children, or volunteering in areas where children are frequently present. Places like childcare and things like that. When we do our investigations, what will happen is a call will come in and we proceed to start investigating. We are required to start our investigations within 24 hours. If there is also a criminal case pending, we will often work with law enforcement on the investigation. And the result of that is that we have commingled information. So if you have, say, a young victim of a sexual assault, it is not best practice to have more than the necessary number of interviews with that child. And so sometimes DCF will either not be present while law enforcement undertakes an interview, or we will be in the room with law enforcement but not speaking. So we often will let law enforcement take the lead. And that is also part of our statutory obligations. Both Title 24 and Title 33 provide that we should be working with law enforcement and that law enforcement should be working with us to do these investigations. We also will rely on other interviews with law enforcement, documents that they may have obtained. So I think I misspoke when I said they're commingled. I should say that we have our own records, and some of the records in our own files come from law enforcement. So that brings me to the question about what happens if a case is sealed or expunged. And we are dealing both with cases that have been brought to trial or negotiated settlement, where you have a criminal charge that's brought that is the person is found guilty. And in that case, those cases can often move forward, but sometimes we are not notified in time of cases of things that might happen. In that case, it might get dismissed. If a case gets dismissed, we sometimes learn, we sometimes don't learn. And sometimes cases are sealed very quickly after a dismissal. And in that case, once it's sealed, we cannot access our records. We will get a notice of the sealing. We sometimes hear from state attorneys, but we frequently do not. And I understand that it is the practice in some states' attorneys' offices for attorneys who were not involved in the underlying criminal case to deal with the motions for sealing. So there may not be adequate communication. So what we are looking for from this committee within the context of this bill is an exception for us to be allowed to use our records, even if a case has been dismissed or expunged by the courts. The standard for our registry is a reasonable person standard at the first level, and at the second level, it's a preponderance of the evidence, and that would be at the Human Service Board level. That's obvious. Those are obviously much lower standards than beyond a reasonable doubt, which is the standard to determine whether a case should be dismissed by the deputy state's attorney or state's attorney. So we do have cases where we have sufficient evidence to place a name on the registry, but we can't move forward because we can't use the information that's in our files. The other thing that happens to us is that we frequently, cases seem to go around and around and around because we learn that the case has been sealed after the criminal case has run its course, in which case we may have information in the file that we can no longer use, so we have to send it back to the district for further investigation to pull the records to make sure that we're only relying on information that we have obtained. So what we were looking for is language essentially that would say that the sealing of a criminal record shall not affect the authority of DCF to access and rely on its own records, including those which may have been reported, collected, or created during a joint investigation with law enforcement. And that we are allowed, that we are allowed to consider those records when we are determining whether a person should be placed on the child protection registry.
Solely for the child protection registry.
Solely for our purposes internally as we move through the case. That's correct.
Okay. Can you provide that language for Michelle Childs at Ledge Council and
I'd be happy to do
the
that.
committee? if you wouldn't mind sending that to us, and we can consider it. Go ahead. Any questions?
I do have a question.
Yeah, sure. Senator Baruth.
Just wondering, under the expungement procedures now, what happens if someone's record is expunged as currently understood before any changes to that? What happens in your shop with their information?
That's a good question. I'll have to get back to you on that. You mean like whether it's actually destroyed or not?
Yes.
Yes, yeah, I'll have to get back to you on that.
Because my original understanding of the procedure was that records were actually being destroyed and eliminated. And so it would be interesting to know if that never happened. But also, you know, my take on this bill is that we're not creating a sealing regime from scratch. We're moving from a full expungement regime to sealing. And so I think your argument makes a certain amount of sense, but so would Department of Corrections, so would law enforcement, so would judges. In an information society, everybody has a reason why they need information. So I'm trying to figure out if we're moving away from the commitment to complete expungement to something like a stronger version of sealing, how that should affect various agencies, including yours. So I'd appreciate that information if you could.
I'll be happy to get that to you. And I think that from our perspective, I just think it's important for the legislature to know the impact if you do take those records out of our hands, literally or figuratively, and to make sure that that's a policy choice that you want to happen.
Well, I think now they're already out of your hands for expungement.
For expungement, I think that's right. I mean, we can.
So we wouldn't be taking them out of your hands. We would be leaving them out of your hands rather than restoring them to your
right,
hands.
But I will say for something like that's true. Once it's expunged, right, it doesn't exist anymore.
But I just want to make sure I fully understand the abuse registry. You call it a different thing. I call it the abuse registry. So if somebody applies for a job at a daycare center or a group home or something that is licensed by DCF, you have an abuse registry. You go back to that abuse registry, and if there's evidence that that person committed abuse on a child, they may not be eligible. That person still has a right to appeal their name being on the abuse. And you have, that's completely private and it's only used by the department in those types of cases. Is that correct?
Employers the employers put in requests for the information.
Well, they're required to by licensing. So
right. So right, exactly. So employers put it in, and then we send the information out to the if they are on the registry, we send it out. Right.
So my question, I guess Senator Baruth's question was, if that record had been expunged, is that person still on the abuse registry? Is that what you wanted to get back to?
I believe we removed them, but I'll double check.
All right.
If we're we usually are notified, but we have to be notified. Yeah.
Yeah. Okay. But your access would be rather limited. And most of the crimes that might be committed that would land you on the abuse registry are not eligible under the sealing bill. Am I correct?
No, it's true that the sealing bill is dealing with crimes that are not generally what would put you on the child protection registry. But given the impacts that we've seen with the current status and the limitations that we're having and the dangerous behavior that we see, we are concerned that we needed this before this bill, and we will need it whether you pass this bill or not. If you want us to continue to place individuals on the registry, we need to, well, obviously we'll put some people
Yeah, I
on.
think it's in the
I don't want to be
interest of
hyperbolic.
Vermont children to have people who might abuse them on the abuse registry. I'm just not clear what crimes that are proposed to be eligible for sealing would put someone on the abuse registry. That's my question. And if you want to come back next week and try to answer that, to look at the bill on are there certain crimes that are eligible for sealing in this bill, H534, that would land somebody on the registry? And are there certain crimes that are already expungible that would land somebody on the registry that you need this information for?
I can certainly do that. I just want to be clear that we are also looking for access to cases that were never brought to fruition by the state's attorneys. So cases that were dismissed, we would still like to be able to access the records because of the difference in the standards. I'm not sure that the state's attorney's offices fully understand that when they dismiss a case and allow it to be sealed or expunged, that we then cannot use that information.
Well,
And I would
suppose
like
that person wasn't guilty.
Well, right. So we would have the information that we gathered in the course of that, right? So the standard is lower for that reason. And I would also say that there are reasons why cases are not brought to fruition because victims aren't available, because they've left the state, because they refuse to testify. Childhood trauma can,
Yep.
it
All right.
makes for difficult cases.
Okay. Okay. Appreciate that. Senator Benning.
Jennifer, you're bringing up an issue I hadn't thought about before, but landing on your registry, does that get triggered simply by you doing an investigation and deciding there's enough to put that person on the registry, as opposed to them being convicted in a court?
Yes. It's a reasonable person standard.
If an individual is found not guilty of the offense in a trial, they are still on the registry?
Yep.
Yes, they can be. Just like O.J. Simpson was found not guilty, but had a lot of civil ramifications for his behavior. It's the same kind of thing. And that's why the legislature put in a lower standard, right? When you passed the law many years ago, you created a reasonable person standard at the initial stage, and then a clear and preponderance of the evidence standard at the human service board level. But there are levels of review.
So wouldn't that be, I'm picking up on Joe's questioning, wouldn't it be trumped by the fact that it has been argued in court and, found according to that standard that the person was innocent? Why would we still penalize them when isn't that double jeopardy of a sort?
Yeah, that's actually accurate. That I misspoke. What I meant was in a case of dismissal. You're right. If we do it would be res judicata. It would be collaterally estopped, right? Yeah, if the person was found not guilty. But if it's dismissed because of lack of evidence or something, then we wouldn't. I'm sorry, I misspoke.
So how would you find out about a not guilty verdict?
If it went to trial, I would think we would know about it, but I'll have to talk to the investigators on the ground.
I think I think,
That's a very important question for me because I had a
Yeah.
trial last week in which this very situation arises. And
I
I'm
think
now
that's right.
thinking,
Yeah, no,
yeah,
and
I want to make sure that my client has the ability to have his name removed from the registry, if that's even possible, because your standard of proof is much lower. And I don't know how that information comes back to you, if it does.
I'll
I'm gonna
find out.
make it,
I can
I'm gonna
find
make
out.
I'm gonna make a suggestion that we have you back next week, and Peggy can schedule that. And if you bring the language, and I think you know many of the questions regarding how somebody gets on the abuse registry who was found not guilty, or who had charges dismissed, or if, for whatever reason. And also, if you could bring us back the appeal rights of the individual. I know that we put those in statute several years ago. I can't remember how long ago, but there's an appeal if your name is on the registry, abuse registry. But there's also Dale also has an abuse registry. And so one of your clients could also be on that registry. And maybe we should ask Dale in as well to make sure that we've got all the registries covered. But I know that I think this is a little more complex than I had anticipated. And I think I understand your request. This is something you'd like to fix whether or not we pass this bill or not.
Yeah,
correct?
we actually have a bill that has been submitted that didn't get any traction, but there are a number of changes we'd like to see in our registry review statute. And I know that there are other organizations that would like to see some changes too, because I think that some of it is proving very difficult, both for grievance
Well,
and.
I don't think we're going to use this bill for that.
No, I
vehicle,
understand that.
But I think the committee would like to see the language in front of them and better understand. I think, are there other questions for Jennifer that she might be able to come back next week and answer for us that committee members have? Okay. And maybe when you come back next week, you could let us know how it works, the sealing of the juvenile record, who has access to that record, both before it's sealed and after it's sealed.
Okay, I can do that. Thank you.
Thank you, Jennifer. Marshall Paul is our next witness on H534.
Good morning. Thank you, Senators. So I testified on this bill last week and ran right up against the lunch hour. And so I was just going to come on today to answer any questions, but I did want to sort of, before I do that, just give a very brief sort of summary of our position and sort of the direction that we see things going. So kind of just by way of summarizing my testimony from last week, our main concern here is that this is a very small bill. Like, this is not an expansive bill. The number of new offenses that become eligible for sealing under this bill is actually very small and very limited. It's limited to felony property offenses and some drug offenses. And frankly, when it comes to the rest of the bill, the main substance of it is to make this change from a dual track system of expungement and sealing to a single track system of sealing. We were initially supportive of that change because, we were sympathetic to the views of the judiciary that the two-track system was really complicated and difficult to implement and was just taking a lot of staff time. And so we were supportive of the idea of moving to a one-track system where the idea was that it wouldn't really be causing substantial changes in who has access to information. It would just be making the process of sealing off that access easier because it would be going through one process instead of through this bifurcated process. So, that was our reason. We did not view the switch from from a sealing and expungement to a sealing only track as being something that would be opening up these records to the eyes of a lot of people who had not been able to see them when they were expunged. And frankly, I think, that was the discussion early on in this process, is that we would move to a one-track system for simplicity's sake. And I think what's happened, as we've seen, is that everybody has come in asking for exceptions. DOC's asked for exceptions. Public safety's asked for exceptions. DCF has now asked for exceptions. And frankly, none of these requests are tied to the changes in this bill. There's nothing in this bill that's making any substantial change in how much information would be available, because it's a very limited set of offenses that would be eligible for expungement under the new bill, or eligible for sealing under the new bill, that are not currently eligible for expungement. That's very limited. So really, the only change that's being made here is the change from expungement to sealing. This information is already information that public safety does not have. When convictions for the past 50 years, for the past 50 years, when people have a deferred sentence and they get their record expunged upon completion of their deferred sentence, that has been information about a conviction that has been eliminated from the records of DCF, from the records of public safety, from the records of DOC, and that's never been a problem up till now. And so I guess that's what sort of baffles me, is that all of these requests for exceptions, these weren't requests that were being made under the expungement regime. They're only being made now that we're proposing switching to a sealing regime. Those same problems existed under the old system as they would now. So to me, it just, it appears that it's sort of an opportunity for people to ask for exceptions to the rule. And what I think is particularly striking is that in no case has anyone tied those exceptions to the science. No one has said, we need an exception to be able to see these records because the studies show that these records are actually predictive of people's future behavior at this point. That's the evidence that's been shown that suggests that we should have these records be, no longer used after a certain point, and nobody's countered that. So from our perspective, really we should be heading in the direction of sealing, and sealing should look a lot like expungement does now. When that information is sealed, it should be hidden from the eyes of law enforcement, hidden from the eyes of the court, hidden from the eyes of DCF, hidden from the eyes of DOC. And if there are going to be exceptions to that general rule, those exceptions should be based on some evidence that this information actually has value that will help protect public safety or protect the safety of police officers or DCF workers or somebody. But so far, the evidence that we see is that, in fact, the value of this information diminishes very, very quickly. And after a few years, it's really not valuable at all. I'm happy to answer any questions.
Well, let's say that after I understand the bill, the sealing takes place, you apply for it, and then after a certain amount of time, for misdemeanors, 3 years. And then at some point, shouldn't the record be like expungement?
That's what we currently have. That's our current system, is that you get sealing for a certain period of time. And then after that point, the record is eligible to be completely expunged. There was a lot of requests made in the drafting stage of this bill to move from that system to a more simple system of just sealing, where instead of having sealing followed by expungement, you just had sealing, but that sealing would be much more restrictive than it is now. And so it would be more like expungement in terms of really preventing that information from being used by the government to make decisions about you. And that's where now instead we have a lot of requests for exceptions to that rule, because a lot of parts of the government want to continue to use that information to make decisions about people.
Who has access to sealed juvenile records?
Sealed juvenile records, that is in Title 33, Section 5117 or 19. And I believe what it says, there's a small list of people who have access to those records. And I think that it essentially boils down to after the record is sealed and the case is over, that it can be accessed by the court for sentencing purposes. So it can't be used prior to sentencing, but it can be used. So for example, if you were charged with an offense as an adult when you're, say, 25 years old, the juvenile record wouldn't come into play unless and until you were convicted and ready to be sentenced. And then they could look back at your juvenile record to make decisions about your adult sentencing.
Thank you. So once the juvenile record is sealed, it truly is sealed except under court order.
I would say that's generally accurate, yes.
Sometimes I wonder if we'd be better off doing no bill at all.
I don't think that's the case. I think that this bill does make some meaningful expansion of the offenses that are eligible for expungement. And that continues to be our office's biggest interest in this bill. You know, the states surrounding us all have many, many, many more offenses that are eligible for sealing and expungement than we do. You know, I gave the example last time of a client of mine, an expungement client of mine, who has a retail theft of $200 from 1992 that she can't get expunged. And to me, that's crazy. In every other state, you can get that expunged. And this bill would allow that to be expunged, and currently you can't.
But my concern is that we passed this bill as it came out of the House, and now we have new exceptions proposed in order to get the administration to agree with the bill and not veto the bill. But that's the reality that I'm trying to deal with here.
One option, Senator, might be to, and this is not something that's been discussed in the stakeholder group or anything, so I'm just sort of throwing this out there as a thought, is that, you know, the exceptions to essentially the new sealing only regime could be implemented only for the new offenses that are eligible for sealing in the new bill. And so that the old regime would continue to be in place for all of the stuff that is currently eligible for expungement. And the changes would only affect the expansion of offenses.
No.
That would essentially mean that there would be no information that DOC or DCF or the courts or the or public safety, no information that they have access to now would be taken away, but no information that they currently don't have access to would be given to them. It would essentially maintain the status quo as far as their access goes.
That would be one option.
And I will, you know, one of the things that's sort of been a thought in my mind throughout this process is that these records become really, they're almost like nuclear waste once they're created. We can't seem to get rid of them. There's a lot, everybody has opinions about where they should go and how they should be treated. And it strikes me that what we don't spend a lot of time on when we're in these committees talking about proposals to create new crimes, to expand crimes, to cover new conduct, we don't talk about the fact that that we're creating new criminal records, which apparently present a lot of problems when we create them. And maybe like nuclear waste, we should be focusing a lot more on creating less of this problem on the front end than on how to deal with it on the back end.
Well, yeah, thank you. Questions from Marcia?
Mr. Chair. Mr. Chair.
Senator Baruth.
So, Marshall, in terms of the idea that you threw out, that would not get at it seems to me the whole genesis for this is bureaucratic or administrative, and trying to rationalize and simplify that two-track system into one. So as I understand your suggestion, it wouldn't remove that problem.
Would not.
Okay, so I tend to be broadly in agreement with your statement of the Defender General's take on the bill. In other words, it seems to me what's happened is in the spirit of trying to ease law enforcement and the judiciary's burden on expungement, we've re-entered a negotiation about how much information they can have in the case of an expungement, because we're now calling it sealing. And so I'm a little disturbed by the fact that when we get testimony from various people, they keep referring to us removing their access to records, but under expungement, they have no access to records. So any access that they gain is a gain for them in terms of information access. So I tend to agree with you that I would like what we come up with in terms of sealing to look a lot like expungement. My question earlier was, were there other states that allow courts only to have access? It sounds like with the juvenile records, that's what we have. How would you guys feel about a bill that gave the courts access to the records, but no one else?
I think we would be okay with that. I mean, we'd have to look at the specifics of it. There's a lot of ways that can be done that would be challenging, but I think that would, in general, I think we would support that. And I think in addition, there's states where they allow broader access, but it's court controlled. So for example, there's a number of states that have sealed records that are available to law enforcement, but only if they make a request to the court and say, for example, we're doing a big drug investigation and we're trying to run down some information that may be revealed in an expunged record. Could we please have access to the records of the following people? And then a court makes the decision about whether or not that's appropriate and how it can be used. And I think that would alleviate some of our concerns with how this information is used. One of our biggest concerns, frankly, is how it's used on the side of the road and roadside stops. The most recent report from UVM showed that Black drivers in Vermont, in addition to being more likely to be stopped, are particularly more likely to have a request made that their car be searched. And the tools to make those requests are often old convictions. I mean, we see it on the body cams when we look at our clients' cases. They often get questions like, I see you have a drug conviction on your record from 2002. Is that something I still need to be concerned with? Or is that something that, is that something you're still dealing with? And those questions often lead into a request to search the car. So we have a lot of concerns about how this information is used, particularly on the side of the road. And those concerns would be alleviated if it was a system of judicial control over those requests.
I appreciate that. That's why I suggested last week that we track the juvenile system for the sealing, that you have a certain amount of time, because remembering here, what I think people forget is a state's attorney and the judge are making a decision whether or not to seal a record. We do not have automatic sealing. If we had automatic sealing, then it might be a different matter. But a state, the interests of justice are presumably are being taken into account at the courthouse when this next Friday, for example, in Bennington County, they expect around 50 people to show up to have their records expunged with the state's attorney and the attorney general. And I think that's a wonderful thing. But it's, if the state's attorney says no, or the court says no, it doesn't get expunged. I think the sealing could be the same way. It's not like you don't have a backstop there. That's what, I've actually long opposed automated sealing for that reason. So anyway. I think, again, I did make that suggestion. It seemed as though Commissioner Sterling was supportive of using that juvenile system. At least that's what he said last week. So are there any further questions for Marshall before we take a break? Hey, thanks a lot for coming back, Marshall. Really appreciate it.
Thank
And
you,
we'll
Senator.
pick at 11:40 at